Namaste friends, hope you are all doing great. Today we'll discuss an important editorial which is published in the Hindu newspaper. This editorial speaks of three things, especially this is circulated around the Special Marriages Act 1954, and then it is also includes Uttar Pradesh Prohibition of Unlawful Conversion of Religion Ordinance 2020, and which also speaks of 2017 Aadhar ruling, which is also called as Puttaswamy Case, in which Supreme Court ruled that right to privacy is the fundamental right. Since then in India, right to privacy became the fundamental human right. Of course, coming back to this case, let us understand the background. Recently in Uttar Pradesh, a Muslim girl decides to marry a Hindu guy. So that is the case background, and it is defined as the interfaith marriages under Special Marriages Act. They went to marriage office. There under this section act, what is this Special Marriages Act 1954, under the section 5, there is an option that interfaith marriages of the couple to give the notice to the marriage officer, and under 6 and 7 that officer must publicize the notice and call for objections for 30 days before this marriage. This is the rule following since that 1954, since that act. So objecting this ground, objecting this rule, this couple decides to go to the High Court saying that this 30 days advance notice and calling for the objections is breaching our fundamental right to privacy. That aspect is breaching our right to privacy according to 2017 Aadhar Act. That is what they claim, and they go to the Allahabad High Court and challenge this act by saying this provision in itself, when we are mature, when we don't have any problem, when we are marrying with the mutual consent, why there is such restriction which infringes upon our right to fundamental right, that is right to privacy. And when this is happening, this may hamper because there are a lot of cases wherein many of the intercaste and interfaith marriages have been taking or are faced with violent opposition. This is the case background. Therefore, High Court has to pronounce some judgment. Hence, it pronounced by saying that this provision might have been necessary during 1954 or during that colonial regime, but today it is not necessary, for the simple reason that right to privacy is a fundamental right. Moreover, our society, which speaks of liberty, equality, privacy and other aspects, which is getting matured, and moreover our act in itself which provides an opportunity under Special Marriages Act for interfaith and intercaste marriages. Hence it says this provision is not necessary if you give it in writing to the marriage officer. Hence there won't be any publication on the notice board until and unless you are agreeing to it, then it is fine. If you are disagreeing, then it is not going to happen. So this is part 1. And inference, what this editorial is drawing in here, this is very important. The inference what it is drawing is that it may be the ground to challenge the act. What is that act? Uttar Pradesh Prohibition of Unlawful Conversion of Religion Ordinance 2020, which was passed in November, which is challenged in the Supreme Court. Already there are 54 cases or 54 arrests already done, and many claim, including this paper, indirectly claims that it could be a draconian act. But also, the government defends it by saying there could be some larger conspiracy which cannot be seen and which couldn't be identified with mere available laws. Therefore, this law is necessary. What does it give? This act empowers two things. One, for the district magistrate to make sure that it mandates 60 days of notice to be published and calling for the objections. And second factor, what it does is it allows or it empowers district magistrates to conduct police inquiry. Why this act has come into the forefront? For the simple reason that there were many allegations, cases, arguments saying that for this reason of getting converted, there going for the interfaith marriages, or interfaith marriages is becoming a reason for conversion of one religion to another religion. This was the conspiracy which was also booked by, or which was also mentioned by NIA. Also many of the Christian organizations in Kerala mentioned about this phenomenon called love jihad, and every other platforms there were allegations. There are even today assertions and other arguments, even ideologies are on that. But fact of the matter, what this article says is, see, already this is getting 54 arrest is very dangerous, and most importantly what they say is, in 2018 case, that was Hadiya case, in which Supreme Court gave the judgment in favor of Hadiya. Hadiya was a girl, Hindu girl, who converted to Islam to get married. So this provision, getting converted to some other religion for the simple reason of getting marriage, is called as Prohibition of Love Jihad Act. And this is in the similar case, NIA also tried to file some charge sheets. Even then, Supreme Court could not find any stable grounds and any stable proofs to prove that Hadiya is getting converted and getting married to a Muslim man with the sole motive of love jihad. That is when it said, it struck down that NIA orders and other Kerala High Court orders and etc., and it freed both of them, saying that if you are mutually consent enough to get married, and if you are of the age which is deciding age for the marriage, then you are lawful. That is what the judgment said. But today there are two arguments which is coming up, and through this High Court's decision, that is what this editorial speaks. One, such kind of anti-love jihad laws are coming up all over, in different states in the country. Hence, this argument which states that 60 days prior notice for the challenge, which has been included in that act, could be challenged on this Uttar Pradesh verdict, Allahabad court verdict, which said that there is no need for such, it breaches the right to privacy thing. And that also means that such kind of breaching of right to privacy in this democratic society or secular society, whatever they quote, that infringes this act. This act actually, Uttar Pradesh Prohibition of Unlawful Conversion Act, infringes upon individual rights and also the liberty and also privacy. That is what the whole editorial is all about. This could be challenged in the Supreme Court. That is what they mention. But fact of the matter, behind this there is a government argument which says that some things cannot be seen or cannot be tackled with the available laws. Hence there needs a stricter laws to unearth the larger conspiracy. At the other end, they are also saying it is against love, it is against individual liberty, it is trying to be draconian against somebody, etc. At the end of the day, the law should shine, for which the argument should incur in such a way that most possible and most best solutions and logical conclusions must lead to proper way of understanding a law, proper way of enacting a law, and moreover that should enshrine the society, which should be the motive of every government and every act. And I hope this editorial was useful to you. Apart from that, it is not just anything but about this Special Marriages Act 1954. We all must know that this act was enacted for the intercaste and interfaith marriages, and which could be a ground to challenge again that anti-love jihad acts. And this other act we have understood, that right to privacy, and new act also, that is the ordinance, we have also understood, which could be a butterfly effect in other states too. But fact of the matter, one thing, that the larger conspiracies, if true, that must be unearthed at the earliest to make sure that there are credible evidences and proofs to prove it before the Supreme Court. Only then this law could survive, and hence the very positive and the right motive should survive at the end of the day. Thank you very much. Dhanyavad. This is Shreyank Asranade. Thank you.